हाय दोस्तों, ब्रास ग्रुप के चैनल में आप सभी का स्वागत है। ब्रास ग्रुप आपके लिए लाया एक नया लेसन। आशा करता हूँ आप लोगों को पसंद आएगा। धन्यवाद।
Young adults who have the capacity to read and understand, so set yourself a challenge and read more. The more you read, the more widely read, of course, you will be yourself, and the better it is for you in ever so many ways. Now let's look back at the preamble. In my previous class, we had gone into the question of the political as well as the legal ramification of the preamble, starting with the words "we the people." And then we had examined, when you say "we the people," does it not imply that the people popularly elected the Constituent Assembly which adopted the Constitution? Yet we know that the reality is not that. There was no popular mandate by which the Constituent Assembly was done. Though, of course, underlying it, there was this broad freedom movement which clearly had put down that we want to have a constitution. Yet there were no widespread elections to the Constituent Assembly. It was held on the basis of indirect elections from the Provincial Legislative Assembly. So to sort out that legal issue, we also notice that Article 395 of the Constitution, which is the last article, repeals the Constitution, the Government of India Act 1935, as well as the Indian Independence Act created by the British Parliament, to create the legal fiction, or what Sir Ivor Jennings calls indigenous root to our Constitution. That is, our Constitution has Indian and indigenous roots. The colonial continuity gets cut off, and you have a break, and you have an indigenous root to our Constitution. And therefore, the preamble and 395 tell you that particular story about dealing with the challenge about whether we the people really gave to ourselves the Constitution. Politically speaking, you know that the Constituent Assembly was backed by this huge upsurge of popular support that India does need a constitution. May I request all of you to turn off your cameras, please? And you find that you are able to justify that. Now let's come to the second point that we discussed in the last class, was the enacting clause. Give unto ourselves the Constitution on the 26th day of November. While that is true by and large, I also pointed out to you what is called the enacting clause. In our Constituent Assembly, this 26th day of November, do hereby adopt, enact and give unto ourselves this Constitution on 26th day of November. Yet, there is an exception to it, which is located in Article 394, where certain constitutional provisions kicked in or became effective on 26th November itself, whereas the rest of them became effective or commenced 2 months later. And which were those articles that had an early entry into force? They are the articles dealing with election, citizenship, very important because people had to decide whether they were there or here. It's an interesting issue of private international law that the Indian Constitution came into effect on 26th January 1950. I'm not going to go into this point. I think it's just too much for second year students, but I'm just indicating to you the possibilities of further study and research. Yet, the Pakistan Constitution, you please remember that when the elections were held in 1945, members were elected both on the Congress Party ticket as well as the Muslim League ticket. And the Constituent Assembly started working from December 1947. December 1947. What is that date? Why is it so important? Because by December 1946, because by that time already the possibilities of partition, and from 47 August, of course, partition was a reality. The Muslim League members boycotted the first 6 months, and then after that, there was no question of those Muslim League members continuing in our Constituent Assembly. Instead, we find in Pakistan that there was another Constituent Assembly, and it's perhaps too long a story for me to tell in today's class because I want to cover other material if time permits in another class. Yet, it is worthwhile noting that from 1947 right up till 1956, how many years is that? Yeah, 9 years.
9 years.
Yeah, it took 9 years for Pakistan to get together and adopt its constitution. So the first Pakistani constitution came into place in 1956, and I think that there is a great learning about what was the difference between India and Pakistan, that India could get its constitution together in roughly less than 3 years, whereas it took far longer for Pakistan. And once again, I have to tell you, this is the only thing that I think I want to spend time on right now in today's class. If I mention to you that language was the biggest stumbling block, not form of government, whether president, whether prime minister, parliamentary, no. Was it whether we should be unitary, federal, quasi-federal? No. Was it whether we should have a Supreme Court, High Court? No. The real meat of the debate was taken up by language. And we are not so different from Pakistan. Pakistan took 9 years mainly because of language. If you went by numbers, Bengali was the majority language. Yet, there was no way in which West Pakistan was willing to allow for that. And therefore, it took a long struggle. And of course, as we know and as history tells us, it was an irreconcilable difference. Never really got settled. And as we know, East and West got separated. Okay, but Indian constitutional history is also in ever so many ways deeply intertwined with Pakistan and Bangladesh constitution. We share many issues, but we are also very, very different. That also I must flag right away. But it's like a cautionary tale for us that was a route, but which we didn't go, and that we came down this route. So, therefore, these were the 2 points that I discussed in yesterday's class. Now, today, I want to come on to what exactly the preamble states. I have in earlier classes pointed out to you that the objective resolution, which was drafted by Jawaharlal Nehru and which was adopted in early 47 by the within a couple of months by the Constituent Assembly, formed the basis for the preamble as it eventually got adopted. Okay, please look up, just go onto the Parliament website, you'll find the objectives resolution, or go into, there are so many websites you'll find that. Justice, social, economic and political. Look at the first, these are what the Greeks would call the important virtues. Okay, justice is a virtue. Okay. Liberty and equality are not truly virtues. The 9 virtues of classical thought. Of them, we find reflections. One of justice, social, economic, and political. And I pointed out to you that primacy was given to social. Social justice because India's deeply divided history, divided across caste, divided across religion, divided across region. And caste had been a very important political issue which was taken head on. It was not sideswept but taken head on by the Constitution. And we have seen that Pune Pact. I'm sure all of you know what the Pune Pact is. And that Pune Pact and the joint resolution that took place, which formed the basis really and the basis, political basis for the stand that India took while going into the first and second roundtable conferences. after the Simon Commission and the rejection of the Simon Commission, which is the India Statutory Commission report, which is there. It's a long 2-volume report. You can find that also on the net. 1929, but 1931. Now that Pune Pact, that we must have the Hindus as a category must be uniform, which means that there must be social reform. And you see a reflection of this social justice. First, I'm going to take in terms of religion. If you look at Article 25 of our Constitution, if you turn and look at it, one of the first things it says is temple entry. All categories of Hindus, irrespective of caste, are going to be granted temple entry. So the earlier discrimination that existed and is done away with, and this was completely a precondition. It was absolute essential in order for it to. So if you look at Article 25(2)(e), it says, nothing in this article shall affect the operation of existing law or prevent the state from making any law, providing for social welfare and reform, or, and I emphasize here, throwing open of Hindu religious institutions of a public character to all classes and all sections of Hindus. That the Hindus as a category would have, so temple entry. And if you look at the legislation, because Hindu religious and charitable endowments is something which is not in the central list, but the states have power to legislate over, state after state between 1950 and 51. If you look at our 9th schedule, don't look now, look after my class please. If you look at the 9th schedule, you will find every state, one after the other, enacted temple entry laws in order to operationalize one aspect of what the preamble called social justice. The other was for providing for reservations and special provisions for scheduled castes, scheduled tribes and other backward classes. For scheduled castes and scheduled tribes, in order for them to have political justice and political equality, the necessity for reserving of seats. You will find seats reserved both in parliamentary elections and state legislative elections, doing away with the separate electorates that had existed following the Morley Minto reforms of 1909 and the Montagu-Chelmsford reforms of 1919. But definitely that there is special reservation. But coming to the other chapters on fundamental rights, that there would be reservations in jobs for, as the Article 16 puts it, scheduled castes, scheduled tribes and other backward classes. And in the second semester, Constitutional Law 2, we spend a lot of time, so I'll come to that later next semester. But for now, we know that the other backward classes broadly comprise what is popularly known as OBCs, other backward classes. And it's a very current topic. If you look at the 102nd and 103rd constitutional amendments, after the class, please look at it very clearly. It tells us that the Backward Classes Commission is the body that is going to determine the composition of social and educationally backward classes who comprise the category of what we call OBC. SEBC, OBC. Don't get confused, they're more or less the same thing. Other backward classes, but Article 15 and the 102nd and 103rd Constitutional Amendment, if my numbers are correct, uses the expression social and educational backward classes. In fact, just I think, is it yesterday or day before, the Supreme Court, you'll find it in live law, the Supreme Court has decided to refer the reservation of jobs in Maharashtra, I think yesterday actually, reservation of jobs in Maharashtra for Marathi speaking people, that is people domiciled in Maharashtra, whether there should be this kind of sons of the soil reservation. You understand what I mean by sons of the soil? Because on the one hand, we have the right to migrate everywhere. But on the other hand, we have Sons of the Soil Reservation. And just yesterday, the Supreme Court has recommended that the Chief Justice constitute a 5-judge bench to go into this question, and simultaneously what it means is also the constitutional validity of this 102nd, 103rd and 109th constitutional amendments. Okay, so social justice takes this variety of forms. Reform of matters considered personal and private in the sense of religion also. Social reform in the sense of Article 17. Untouchability is such an egregious offense against humanity that one cannot turn around and say, I'm practicing it within the 4 walls of my home. There's no public, there's no private. Untouchability in any form, anywhere, in whatever be the circumstances, is an offense. And Article 17 makes it an offense. I mentioned in my earlier class that the Indian Constitution is unique because it's perhaps the only constitution in the world that defines an offense in the Constitution and in the chapter of fundamental rights. It says it's an offense, and Article 35 talks about the punishment that can be levied, which you find in the Civil Rights Act and the Prevention of Atrocities Against SC/ST Act. Okay, that's made, the punishment, etc. is made, but the definitions here. So, social justice has so many components. Then I come to economic justice. I'm saying this because yesterday when and in Madhya Pradesh too, but the challenge has not yet been accepted, Nirpanshu, yet by the Supreme Court. Okay, so I'm not dealing with that. It's on Maharashtra which has come up. Now, economic justice. Yesterday, I'm sorry, there were comments, but I could not address all of them in class, so I'll take it up today. I had talked about expropriation and the right to property as a means of economic empowerment, economic justice. Yet the Constitution, as adopted, also upheld the right to property. Okay? So, the question is, how are we going to deal with economic justice? And I think that our Constitution has many. Currently, of course, we have taken away Article 19(1)(f) after the constitutional amendment. It's now a constitutional right. Now, expropriation by definition means without compensation. Okay, you can take over private property. This is the power of the state, which is called the power of eminent domain, the power of the state to acquire. But that very special acquiring without compensation is actually what is known as expropriation. Okay, and so the power of eminent domain continues, but we give compensation. So even now, if you look at the Land Acquisition Act or its new avatar, which is the 2013, it has a long title, Rehabilitation something Act, allows you to give compensation on market terms. There are many other aspects of economic justice. In my opinion, economic justice is not only about wealth, it is also about income, and therefore income tax, having differential income tax for people who are high earning individuals, lesser earning individuals. If you think about it long enough, you would agree with the proposition of some political scientists that even reservation of jobs is a form of economic justice. People who are earlier unable to get jobs in the organized sector, particularly government jobs. You know that some states have jobs in the private sector which are going to be reserved, but not very many, is also a form of economic justice. So economic justice, I think, has many, many dimensions. It's got wealth, it's got distributive justice at the heart of it. How do I economic justice by result? So all redistribution programs, differential taxation programs, all would be justified by the preamble. I already mentioned to you yesterday that the preamble is a complete part of the constitution. It doesn't stand outside of it, and therefore you can resort as a good lawyer. If you were arguing a constitutional law case or any other case, your ability to develop an argument, your ability to press before the court that an existing word whose meaning has been settled should be re-looked at and once again reinterpreted. That capability of advocacy comes by reading, say, a preamble together with a legislative text or with a constitutional text. Remember, if you've decided to become a lawyer, the final answer has still not yet been given. Even every settled question can be re-agitated and can be argued. So a lawyer is one who says, never say die. And you know that words have meanings and meanings are not written in stone. Reality, it may perceive to be fixed in stone, but nothing in our constitution is fixed. It's constantly being interpreted. So, in fact, the American constitutional lawyers have a phrase for it. They say that we must interpret the constitution because it is a constitution. But each generation has to interpret the constitution afresh because a constitution is not a dead piece of wood. It is a living tree. And so there is this very nice approach that a couple of constitutional judges said, which is now, of course, very popularly used, a living tree approach. And so when you say, do you follow a
Ma'am, you've gone on mute.
Sorry. At which point did I go on mute? Was I on mute during living tree?
Ma'am, yes,
Living tree approach. Yes, ma'am.
Okay, thank you. So, a living tree approach that, living tree approach, meaning thereby that each generation can interpret the constitution afresh. So, it's a phrase that comes to us from the American Supreme Court. Or the other one is, I'll type it in here so that I don't make a mistake for you. The other approach is actually one of originalism. Okay, originalism, what the founding fathers. Okay, this is again from America because they had no founding mothers. Did we have any women members in our Constituent Assembly?
Yes, ma'am. Rajkumari Amrit Kaur, ma'am.
Yeah.
Prominent name.
And
We have a lot of them.
Dakshinay 15 of them.
Madam Durgabai Deshmukh.
Yes. So, when people say founding fathers, you know that they're referring actually, or either they are very chauvinistic people who believe that only men should have been there. Okay, there are quite a few of them around, you know that. Or they're referring to a phrase from American constitutional law, founding fathers truly. So, what you find is therefore, as a lawyer, never say die, don't give up, don't say, oh, I don't find any articles to support me or any judgments. Doesn't matter. You reopen the fresh debate and say that there must be a fresh perspective. And so U-turns have characterized a lot of judgment making in India, and therefore, well, why not you either? Political justice, and as I mentioned to you, political justice that everybody must have a right to vote, everybody must have a right to participate. So if you look now at the amendments that are still pending, and there is a bill pending in the Rajya Sabha about reservation for women in legislative assemblies. Already there's reservation for women in panchayats and municipalities by virtue of the 73rd and 74th Constitutional Amendment. But that would be an example of political justice because you're looking then on the category of gender. But you could also look at the question of reservation in political participation. So political participation as students of law, we know, has so many dimensions. One is the right to vote, but the other one is also to stand for election. And thirdly is the right to speak and to participate. And the right to participate has ever so many concentric circles around it. You could say, I need to be educated, etc. So one of the questions that has arisen in a judgment of the Supreme Court delivered some years ago, whether it is correct that people who have more than 2 children should be prevented from participating in Panchayat, Haryana case. Okay?
Yes, ma'am.
Is that a denial of political justice? So if you look at the argument of the petitioner in that case, because they had challenged this law, but they did not really get the support of the Supreme Court, unfortunately, was premised on the principle of political justice. What I'm telling you is that when you look at these words, don't look at them only as big words that you just study, vomit in an exam. No. If you are a lawyer or a judge, they are words with a lot of content, and any case, if you are imaginative enough and if you are fired up enough, you would be able to draw some principle out of that into passed in Rajya Sabha, not passed in Lok Sabha. Okay, thank you, Rajneesh. I stand corrected. This is about the women's reservation. Okay. Now come to liberty. Now, liberty, equality, fraternity. Look at these 3 big words that are there. What does it remind you of? These 3 big words.
French Revolution.
French Revolution. Yes. And why does it remind you? Tell the rest of the class. Somebody who spoke first. Who would like to just tell us why it reminds you of the French Revolution, please? Who would like to speak? Who's now? Yeah.
The principles were first proposed during the French Revolution, when the idea of equality of human beings and the liberty of doing any occupation. Because of the estate system, they were demanding liberty and equality of status.
Yes.
So that's
Which were the estates that were demanding equality?
On the third estate.
Third estate. Yeah. Tell the class what are these estates.
Ma'am, your voice is breaking. Can you please repeat?
I said, Madhunika, tell us a little more about these estates.
Ma'am, the first 2 were clergy and nobility. I'm not sure which one was the first one. And these 2, they used to receive 2 different kinds of taxes from the third estate. Third estate was the working class, and they involved artisans and these lawyers, professionals, and they weren't very happy with this taxation system.
Right. And which years are we talking about, Madhulika?
Ma'am, 1789 was when the revolution took place.
And so, that they guillotined Louis XIV. You know that the great French Republic came, and on their banner was when they stormed the Bastille, 14th of July, is when they broke those jail and let out the people, and that's when it happened. And liberté, égalité, fraternité, that was the banner that was inscribed, and we know that our constitution took these 3 phrases because they were so influential, not only in France, but at the time earlier itself. John Locke, when he was writing his 2 treatises on the civil government, which influenced the American constitution, he talked of life, liberty and property. However, he wrote in sometime in 1724. But by 1776, when the American Revolution happened, they dropped property, and on the American Declaration of Independence is inscribed life, liberty and the pursuit of happiness. So they dropped property, and their great trinity, which was life, liberty and property, got replaced by this trinity of life, liberty and the pursuit of happiness. And they did not take equality there. Okay. And it's quite significant that they did not choose equality as one of their important constitutional goals or their country goals. And I think in some ways, the Black Lives Matter also is a reflection of what has happened in that society as a result. Okay. So that was equality of France was not taken in US, and I'm sure you're all wise students. You can understand that there are many repercussions of this. Voice gone again, ma'am. Has my voice gone?
No.
No,
No, ma'am. No, we can hear you.
No, ma'am. Okay, no, somebody just chat on the chat box told me. Okay. Now, which are the liberty? Liberty of thought. Look at this liberty of thought. I find it quite incredible that we must have liberty of thought. Is there another phrase that our constitution uses for liberty of thought? Anybody?
Freedom of expression. Freedom of expression.
Expression is different from thought, no? Expression means you're giving a outwardly manifestation of that thought. You express it in writing. You express it in a song. You express it in your speaking. So when I speak, you have some glimpse of what I'm thinking. But really, you don't have a full idea of what I'm thinking, right? Because that's in my head. But I can express. Yes. Another phrase that our constitution uses.
Freedom of conscience.
Yes, very good. Freedom of conscience. Was that you, Mitansh?
Yes, ma'am. Yes.
Yeah. So freedom of conscience. It's used in Article 25, and that is actually articulating what the liberty of thought is. That it's something in your head. Now you can ask the question, or you can think through the question. In a society, your actions matter, because if I'm going around giving everybody a hit or a muka, then I'm going to be harming them, right? So my actions need to be controlled because they're external manifestations. My expression also needs to be controlled, because sometimes, I don't know if you agree with me, but I think words are sometimes even more powerful than even your physical action. So sometimes a word that a teacher says, or a word that a parent says, or a word that a close friend says can be wounding you for years and years later. Whereas some slap given by a person will heal in a few days, okay? So words are so powerful. Why do you think we should have freedom of thought? Why should that have been written in our preamble? Anybody?
Ma'am, for development, you need free thought. And if there's no innovation in terms of innovative ideas due to restrictions on freedom of thought, there can't be a proper progressive society either.
Ma'am, the main objective of democracy is that every person can think differently.
Okay, Akshay, what is your view?
Ma'am,
Yeah, just Akshay, then you, Prabjot. Prabjot after Akshay, please. Yeah, Akshay. Akshay Kumar Yadav, go ahead.
Yeah, ma'am, it allows us to think beyond what we are supposed to think socially. Like if we have a different kind of thoughts running in a society, different kind of ideologies running in a society, influencing our mind and thought system. This freedom allows an individual to think beyond that, have a different perception.
Sure, I agree. Yeah. Prabjot, you're just very briefly, why do you think?
I think it is not necessary to mention it in the constitution, that because thought cannot be controlled by any means of outside means. So I think
is it a worthwhile goal to have? Is it a worthwhile goal for us to have as a country?
No, ma'am, even if it is not there, we can thought whatever we want to. It is superfluous, I think.
It's superfluous. Okay, how would you says, yes, somebody who's not spoken till now.
Constitution wants to create a free society in which dignity of individual is recognized to the very major extent.
No, Prabjot's point is it's superfluous because you have no way of monitoring whether there is indeed freedom of thought or not. How will you?
I think incidental to freedom of thought is the access to neutral, wholesome information, wholesome knowledge, so that people can assess and make their own viewpoints, whether to criticize something or whether to support things.
So I think your point is we need freedom of thought because in an instrumental way, that way any information that we receive, we are free to process how we want.
Yeah, and the information are confident and in a very true and distorted information would obviously influence our thought. So we might think that, okay, this is the truth, but in reality that might not be the truth, and we're in a very distorted manner.
Yeah, thanks.
Ma'am, I think that
Parth and Rajneesh, hold on. I've got Yugal, then two of you. Yeah.
Basically, ma'am, freedom of thought helps to develop the individual personality, and individual personality is basically one of the virtue of democracy, ma'am.
Okay, thanks. Parth, quickly.
Ma'am, according to me, this is for the right of indivisibility, to exercise indivisibility. Ma'am, this is not given by the Constitution. It is a natural right.
It's a natural right.
The Constitution recognizes it. Constitution has just recognized
no, that's a very good point you make. Good point you make. That it's not given, but it's being recognized. Perfect. Rajneesh, very quickly, please.
I think it is essential or the founding stone of the democracy, because if as every individual consists is thought to be consist of body, mind, and soul.
Yeah.
Now, if body is free but mind is not free or is not at liberty, then I think having that free body is like having a slave in the mind, particularly.
Yeah. I'm sorry. I got it. Now look, there are also very many ideas that have come up on the side. Principally, if you look at what many of the students have written in, is that because if we don't have the freedom to think, there would be no allowance for dissent. We degenerate into a totalitarian state, which is not only controlling our actions and speech, but also going even deeper to the level of thought control, right? And I think that that's what many of the students who have written on the side are saying. Now, some of you are saying that even if it's not written, it is superfluous. However, I think that there is a virtue in putting down these things. Why do we put down an aspiration? It prevents a backsliding later on. So if you look at our constitution as a document that has a set of values which is there. One, we want freedom of thought. Sure, we should have what Chief Justice Holmes of the American Supreme Court called a free marketplace of ideas. So if you want a free marketplace of economics, you should also have a free marketplace in politics and have a free marketplace. But one of the reasons, and I'm addressing the point that Prabjot made and some of you have made on the side also, it's not superfluous. Look at it this way, that if you put what your highest aspirations are in black and white, it would require an amendment to have it taken away. And that way making a backsliding or a reversing or a downgrading of the highest aspirations that much more difficult. So it sort of ratchets you into that place, and that's actually what a constitution does. It's an articulation of an agreed upon set of values. And by putting it in black and white, it makes it that much more difficult. Now you take the English who never had a constitution, but there was just some general unsaid agreement. I'm talking about before the Human Rights Act 1968. A gentleman's agreement that this is what our constitution says. But you know that public opinion can change very, very fast. You have people who can change public opinion. So far better, today there is almost no country which doesn't have a written constitution, so that you lock it in place. Okay. Therefore, let's continue. Freedom of thought, and therefore thought control would be a violation of your freedom of conscience. I don't think science and technology has yet reached, but in the next semester when I come, we're going to look at those lie detector tests and what is that other thing that is put?
Narco test.
Narco analysis, yes, narco test. That's right. Where actually, sorry. Yeah, you know what I'm saying. Yeah, that is whether that violates the freedom of thought, because your deepest thoughts, somebody is secretly entering your head like a spy and then pulling out your thoughts out of you, which you would never have told the police or the investigating agencies in other cases. Is this constitutional or not? And you have a 5-judge bench that says no without. Yeah, sorry. Yes. Was this something? Anyway, so that the question of thought, therefore, is not just aspirational. I'm telling you, the science and technology, we've already seen the first inroad into our mind in terms of lie detector test and narco analysis. But there are other forms which, science, we don't know which way it will go. There is more and more thought control which is possible. Okay, you only have to see cinema or books to know that the possibilities are huge. Okay, and therefore, so freedom of thought. Then we come to expression, and expression, of course, embodied in Article 19(1)(a), speech and expression, artistic speech, commercial speech, written speech, political speech, all forms of expression. So it's not only political thought, it can be artistic thought. Currently, there is nothing to prevent somebody from having pornographic, erotic thoughts. We cannot prevent. Its articulation can be regulated in some ways. Likewise, so what I'm saying is thought and expression is not only political. The Constitution is not dealing only with political thought, because normally, we think that it's political speech or political thought alone that should be. My point is artistic thought, erotic thoughts, romantic thoughts, seditious thought, whatever kinds of thoughts are all kinds of thoughts and expression which the Constitution is dealing with. Belief, faith and worship. When we come to the next semester, belief again in your own mind, but faith and worship are external manifestations. So in everything, there's this inside and there is this outside. There is that emotional, affective forms of thought that are going on in your head, which also can be legally protected. I must emphasize this point because if you look at the kinds of litigation that is coming in courts, and which is the kind of litigation I think that you young people will be confronting. So you look at whether it is under Narcotic and Psychotic Substances Act, or you're dealing with child labor cases, or you're dealing with marital disputes, or you're dealing with even police detention. A lot of it is to do with thinking and expression, etc. Now we come to equality of status and of opportunity, and to promote among them all. Equality of status and of opportunity. You can straight away see both a static and a dynamic form of equality that is there in our constitutional preamble, and which is there in our the chapter dealing with articles dealing with equality. So 14, 15, 16, 17 and 18. Opportunity means that you have an opportunity to become equal. It's dynamic. I must tell you right away, this is a very sharp point of departure between our constitution and the American Constitution. Even today, any form of what is called set aside or reservation is subject to constitutional litigation in the US. Because I already pointed out to you that equality was never picked up as one's goal. And the equality that is there makes, if you reserve seats for women, then there is a problem. You have to meet some constitutional challenges. Of course, sometimes they're able to overcome it, but it's still a big deal, which is why our Supreme Court, in a case that we will be doing further on along down the year, Supreme Court has said that America is not a good comparison for us when it comes to equality jurisprudence in some matters such as reservation. So you can have opportunity. So Article 16 says all citizens have equality of opportunity. And equality of opportunity means different people with different capabilities can have different types of opportunity. So you can have a race where everybody doesn't start equal. You can stagger the race because you feel that equality means that those who have a problem can have more. So you can see even in our exams, if there is a person who has a writing disability, we give half an hour more. Half an hour more not to make equal, but half an hour more because we want to make them equal. Okay, so that would be equality of opportunity, and you see this as a running thread right through many provisions of our constitution. That its justification comes from the equality of opportunity that we have here in our constitution, laid out in our preamble itself. So there's the static maintaining equality, preventing a further impoverishment or a further downing of a person's status, as well as equality of opportunity, which means thereby that we move away from a historical approach where we say that people's position is determined by some historical status, and it is unequal, it is unequal. No, it's not. The history of all progressive societies is a movement from status to contract. That's what Sir Henry Maine very famously said, that your position will be maintained by contractual equality. Everybody must be treated equally. There's much more, we can go on and on, but the point is that equality was pulled out as a very important goal laid out in our preamble itself, and in that sense we are more akin to the French Declaration of 1789 rather than the 1776 Declaration of the US Constitution, at least with regard to equality. Fraternity. Okay, what does fraternity mean? Anybody? Somebody who's not, somebody means I'm sorry, I'm wanting somebody who's not spoken before to speak. Fraternity.
Ma'am, it means brotherhood.
Brotherhood, yes, Rupali. What would be why do you think it says brotherhood and not sisterhood?
Well, ma'am, obviously it has to do with the history of, you can call it patriarchy, or in the sense of how chauvinism is built.
Okay.
But I think that
so we are going
thing that I think it's emphasizing is a horizontal relationship rather than a vertical one.
True. So we will go for the essence of it, which is that, all men are equal, meaning in that broad formulation of men, all humans are equal. So we move to a human-based approach, but of course it's there, so we accept it for what it is. Please remember that there was a fraternity is one word. The sisterhood, what is the word that has historically been used for sisterhood? Equivalent to fraternity. What is the word?
Ma'am, it's sorority.
Sorority, exactly. So the sorority of women, Dipanshu, thank you. So for our sorority, but we're not nitpicking. We are not doing a gender analysis of this. We are going to take the essence of what it is, assuring the dignity of the individual, and so the fraternity which assures the dignity, that is all men are equal. What a very well-known jurist called Ronald Dworkin called equal care and respect for each and everybody. And we cannot be a fraternity if we don't accord. Now this is a very profound value, and I think that as students of law, each of us must have constantly tried to re-examine our behavior. It doesn't mean that you must become mushy and say, I love everybody. No. But you must treat everybody with equal dignity. And there has to be a transformation. Otherwise, we would be real fake people doing constitutional law. It's a very profound value, because if one cannot respect another person or another person's view or thought, or one is willing to fight till the death saying mera view hi sahi hai, then you're not acknowledging that another person can have another point of view. And if we have learned nothing else from our study of constitutional law, the most important lesson to me is not the marks or some million things that 10,000 billion people before us told us, or knowing some 200 cases, is the essence that we must learn to respect other views, other thoughts, other forms of living, other ways of being, because that's a constitutional value, or what the court now calls constitutional morality. The Second Amendment, unity and integrity of the nation. Okay, unity and integrity of the nation. I'm going to stop here because coming from Monday's class, I'm going to begin with Article 1, 2, 3 and 4. Okay, and I will be taking up perhaps I need one more class to just go through the quick features of the Constitution, and then I will be beginning 1, 2, 3 and 4. So I'm going to stop here now, and I would like you to look at this closely once more. And I had asked everybody to read the introductory extracts from Keshwananda Bharati's case that deals with the preamble. S.R. Bommai's case, which deals with the nature of whether we are federal, and there are other beautiful words used there, amphibian, all kinds of strange words have been used, okay? All very interesting. Look at that. And then we will be continuing in our next class, okay? So I think I'll stop here now for
Can I ask a question?
Yes, please. Who is that who's speaking?
Ma'am.
Yugal, yes.
Ma'am, actually, preamble starts with, ma'am, 3 words, we the people. And when Constituent Assembly is elected, it was elected by, ma'am, merely 10% of Indian people, ma'am, who were franchised. So, ma'am, my question is, when sovereignty lies with people in India, how can we say, ma'am, that Constituent Assembly have a mandate of all the people?
Yugal, you have been in my class today and yesterday, and
Yes,
you know that I'm going to just take 30 seconds, okay, like this TV programs, and give you my answer. It's going to be, because I don't want to repeat it, but that issue that there was no universal franchise is met by the fact that the Constituent Assembly had the implicit support of the people
Yes, ma'am.
as a result of the freedom movement. Number 2, the ability to say we the people comes about also because of 395. We repeal that. So we actually say that while they are elected, they speak for the people. And the popular acceptance of the Constitution is what is giving it its. You studied Kelsen in your first year. The norms of the Constitution, why it is the Grun norm, is not only because it got voted by the majority. It is the Grun norm because normatively it has been accepted by the majority of the people. However, Yugal, because I don't want to delay the students who need to get attendance, they have to go to another class. I'm going to stop here and we can continue in the next class.
दोस्तों, ब्राज ग्रुप आशा करता है कि आप सभी लोगों को ये लेसन पसंद आया होगा। आप अपना फीडबैक कमेंट बॉक्स में देना न भूलें। थैंक्स फॉर वॉचिंग।